Despite a landmark Supreme Court ruling that seemingly invalidated the tariffs imposed by the Trump administration on billions of dollars worth of imported goods, U.S. importers are still being forced to pay these contested duties. This ongoing financial burden, levied on a wide array of products, is creating significant frustration and economic strain for businesses that had anticipated relief following the High Court's decision. The situation highlights a complex legal and bureaucratic quagmire, leaving importers in limbo and questioning the enforceability of judicial rulings against executive trade actions. The Supreme Court's decision was widely interpreted as a victory for businesses, suggesting that the Section 232 and Section 301 tariffs, originally implemented on grounds of national security and unfair trade practices, were improperly levied. However, the practical reality for importers has been starkly different. The U.S. Customs and Border Protection (CBP) continues to collect these tariffs, citing ongoing administrative processes and a lack of clear executive guidance following the court's ruling. This disconnect between judicial pronouncement and executive agency action has left businesses facing continued uncertainty and financial penalties that many now consider unlawful. For many U.S. companies, particularly small and medium-sized enterprises, these tariffs represent a substantial operational cost that cuts into profits, inflates consumer prices, and hinders competitiveness. The prolonged payment obligation, even after a favorable Supreme Court decision, creates a chilling effect on international trade and strains supply chains already grappling with global economic volatility. Importers are now advocating for immediate action from the executive branch to align tariff collection practices with the Supreme Court's judgment, seeking refunds for duties already paid and an end to future collections. The prolonged legal battle and the current impasse underscore the immense power of presidential trade actions and the challenges of unwinding them, even with judicial intervention.